I like this name right here. Alternative/exotic contracts. Ooh, exotic contracts. That sounds spicy, doesn't it? An exotic contract. It's not that exciting. So, let's talk about contracts, okay? I told you got to keep them straight in your head about the differences between basic contract law, right? Contracts in general, real estate contracts, and then a very, very specific contract. Because they all work similarly, but some of them work differently. And then the other thing is you've always got to think about the parties to a contract. So I played this game with you before, but let me ask you. Who are the parties to a listing contract?
The seller, the listing firm.
The seller and the listing firm. Absolutely. Who are the parties to a buyer agency contract?
Buyer and the selling firm.
Buyer and the selling firm, or buyer and the buyer agent firm, right? The buyer and the firm. Who are the parties to a sales contract?
Buyer and the seller.
Buyer and the seller. Who are the parties to a property management contract?
The owner or landlord and the tenant.
The owner in the property management company?
The owner in the property management company. The tenant's not part of that, right? Tenant would have a lease agreement. That's a different type of contract, right? A lease agreement between property owner and the tenant. And so you've got to be very careful and think about the parties. And the reason is there's going to be a lot of questions based on the parties and what happens to the parties. And remember, I told you before I even get into this, death of the parties does kill agency contracts. Death of the parties does not kill sales contracts. So not all contracts die the same way. And so you've got to pay very careful attention to what type of contract we're talking about, who are the parties to the contract, and what are we asking you. Okay? So, I like this name right here. Alternative/exotic contracts. Ooh, exotic contracts. That sounds spicy, doesn't it? An exotic contract. It's not that exciting when we get there. I've never really heard them use that terminology very often. But whatever. So, let's talk about what a contract is first, okay? It's important to understand what is a contract. We're going to test you so stinking much on it. By the way, this is the most testable section. Financing is 12 questions. Basic contract law is 13 questions. That's a lot. 13 questions, okay? So a contract, it's got a couple different definitions, but ultimately it is a legally enforceable set of promises between legally competent parties. I'm going to say that again. A legally enforceable set of promises between legally competent parties. I want to ask you a question. Do you think that people ever make promises to each other and then don't fulfill them? Sure.
All the time.
All the time. All the time. Now, folks, I want you to think about that. If we were just understanding of the fact that people don't fulfill their obligations all the time, then we wouldn't need contracts. Contracts are, by design, supposed to be powerful enough that it really feels like somebody is going to do what they said they were going to do. And in fact, if they don't, you have the ability to get some kind of remedy, right? But let me make something abundantly clear. Contracts, as powerful as they are, as important as they are, as they are designed to be, these things, are worthless unless you're in one very specific location. Where do you think that is?
North Carolina.
person giving the contract?
Court.
Court. Court. Folks, think about it. If I sign a document with you right now stating that I'm going to do XYZ PDQ, and then I don't do it, what the hell are you going to do about it?
File a lawsuit?
Maybe. It depends on what it is, right? Because if I promise you that I was going to give you $1 back, are you going to go see Judge Judy when I don't give you $1 back? Jamil says, hell yeah, I'll see you in court, brother. You get your papers tomorrow, okay? I need my $1. But do you see what I'm saying? It doesn't mean anything if you're not willing to take it to court. So the presumption is it has to be done in such a way where it is legally adequate to go after somebody, right, in court. And if you're not willing to go to court, it never meant anything in the first place. You might as well have not even had it. And so that's why the definition says legally enforceable. Legally means in a court of law. Legally enforceable. You have the right to go after somebody in court. Legally enforceable. Otherwise, it's a handshake. That's not legally enforceable in a lot of instances. Maybe it is, maybe it isn't. We're going to talk about that. So, there are so many different contracts that exist in the world. And even within our curriculum, right, in real estate, we've got, as we just said, agency contracts, sales contracts, promissory notes or types of contracts, leases or contracts, independent contractor agreements between the real estate brokerage firm and the broker. We got lots of contracts, folks, lots of them. And so the idea behind all of them is we want them to be enforceable. We want to be assured that you have to really do what you said you're going to do. Because if we don't have any assurance there, what's the point? And that's everything that you have to understand about contracts. They're designed to meet certain criteria. They're designed to be enforceable. They're designed to do a lot of things. But even if you do them correctly, if you're not willing to take somebody to court over it, then it was pointless. Why did you go through all that effort to create a contract? Does that make sense? Now, even in a real estate point of view, okay? I told you it's a set of promises. Buyers and sellers promise each other things all the time. Do you think there's ever times where the buyer and the seller maybe don't uphold their promises to each other? Yeah. Happens a lot. And so I want you to picture this. If a buyer was promised a chair, okay, because we could negotiate anything in real estate. If the buyer was promised a chair and the seller didn't leave it, that means that the seller did not fulfill their promise. They may have fulfilled part of them, but not all of them. But let me ask you this. Jamil aside, are most people wanting to go to court over a chair?
No.
No. So the contract exists to ensure that you get what you were promised to get, but sometimes it still doesn't happen. And if you're not willing to go to court, then you never really were that protected in the first place. And so sometimes we just suck it up, buttercup, right? We're like, well, it's not worth going to court over. I didn't get a chair. It is what it is. And so that's what you have to understand about contracts. They're not perfect. And especially if you're not willing to go to court, they're useless. But you still need to know how they work, and you still need to know where they're enforceable and how you protect yourself with said contracts. Now, let me make a couple other statements here in regard to these, okay? You are not authorized to draft contracts as a real estate broker. When I say draft, I mean create them, okay? We're not attorneys. If you draft a legal document on behalf of another, that is the practice of law. And since we are not attorneys, we cannot do that. So what we do is we fill in the blanks on a pre-printed draft by an attorney, right? We have these standardized forms with blanks. That's what we are. We are glorified blank fillers, right? That's what we are. We can put in purchase price, we can put in closing dates, we can put in different terms, we can negotiate things, but there's a set of blanks for us to fill in. We can't do specific verbiage, we can't add things, we can't take things away for other people. That's not allowed. Mallory says, first house I bought was supposed to come with new wooden blinds, and they did not fulfill the contract. It wasn't worth court, obviously. There you go. Happens all the time, right? All the time. So, I want to make a note about contracts here, because this is going to be important, okay? We can't add in verbiage on behalf of other people. We can't draft agreements on behalf of other people. The key word that I want you to take away from here, the words, is other people. Because if you do these legal documents or make legal changes to a document on behalf of others, that is the practice of law. But think back to agency, folks. Can't you represent yourself in a court of law without an attorney? Can't you buy and sell a house yourself without a broker? And so by that same token, understand that a party to the transaction can do whatever the hell they want. If our buyers and sellers wanted to handwrite a sales contract on a napkin, they could, because they're writing it for themselves. If they wanted to type up their own legal addenda, which is the plural of addendum, we're going to talk about addendas, they are a supplement to a contract. If they wanted to type up their own, they could. Why? Because they are a party to the contract. If you are a party to the contract, you can make changes, because it's not the practice of law. You're doing it for yourself. Does that statement make sense? So, let me give you a scenario and then ask you a question and see if you're tracking with me here. If I had April as a buyer, and April says, Seth, I want you to put in some verbiage that says that I get my due diligence and earnest money back if I can't sell my house. By the way, that's called a financing contingency or something like that, and that's a legal thing. And so if I am April's agent, could I write something like that into her sales contract?
No, fix her.
There you go. No, because that would be the unauthorized practice of law. Now, could April write up her own document that stated that, and then we add it into the contract?
Yes.
Yes. It would be ill-advised, though, because April's not an attorney, and so we should probably contact an attorney if we want it to go through. Does that make sense for everybody? But can she legally add it in? Sure. Well, I want you to think about it for a second. If I'm April's agent, I can't do anything like that in the sales contract, but there is a contract that exists that I could make changes to. What do you think it is?
Agency agreement.
There you go. Agency agreements. Why?
About myself.
We're a party to the
We're a party to the contract. More specifically, our firm is. But remember, we're a general agent of our firm. We have the authority to bind our firm to things. So could we write in verbiage and make changes on an agency contract? We could, because we are technically a party to it. Does that make sense? And this is why I told you, you've always got to be thinking about who are the parties to a contract. Because if you're not one of them, you better not be making changes to it, right? The people who are parties to them can. Is this making sense so far? Now, we wouldn't really write our own agency contracts. It's not worth it. We have standardized ones that we use, but we can make those tweaks or edits if we wanted to add in verbiage, take out some verbiage because we're a party to it. And then remember, in North Carolina, all written agency agreements under North Carolina license law and commission rule have to contain 4 things in the written agency agreements: non-discrimination provision, license number of the individual licensees, signatures of all parties, and there you go, definite termination date. Nailed it. Thank you. Sometimes I teach so much, my brain just goes nuts. Let's talk about the next piece of this, okay? If I looked at Jacob and said, Jacob, I'll give you $20,000 for your car right now. Do we have a contract? What was that? What did I just do?
That's an offer.
That is an offer. That is an offer, okay? Folks, every single contract in the world starts as an offer. Every single one. I want to buy your house for $500,000. I want to buy your car for $30,000. I want to do this, right? It's basically an offer. Every contract starts as an offer, which means contracts are always voluntary. Always voluntary. So I want you to look at this lovely, lovely young couple here, okay? Homeboy is presumably down on one knee right now. And what did he ask her? He said, "Will you marry me?" Folks, are they engaged? No. Not until she says what?
Yes.
Yes, right? Folks, she could say yes. She could say no. She could say nothing. And this is exactly how contracts work. You've got to get a response, otherwise you don't have a contract. That's ruthless, April. April says, don't do it. It starts as an offer. Will you marry me is the offer. And she can accept it, she can reject it, she can say nothing. So what happens is we only move into a contract when somebody accepts our offer exactly as written. Because, think about this scenario. If she says, maybe ask me again in 3 years, do you think that's going to go over well with him?
No.
No, they're probably not going to be together anymore. If he's smart, right? Like either know or you don't know, right? Like let's not revisit this. And so that's the thing. That is what would constitute a counteroffer. If you suggest something else, you have killed that person's offer. That offer's not on the table anymore. Okay, when we get into this, offers should be thought of as living, breathing things. I want you to think of offers as some pretty flowers. The reason I like flowers is because we can talk about killing them and it doesn't get like super morbid or dark, right? If I give you flowers and you kill them, you can't bring them back, can you? Could you buy the same flowers and give them to me? Sure you could. But you can't bring back the flowers that I gave you. Does that make sense? So offers should be thought of as flowers. When you kill them, they're gone. And so when you make an offer to somebody and they don't accept it, your offer's not on the table anymore. If they reject your offer, if they counter your offer, if they do anything, now we're going to get into that piece more. But every single contract starts as an offer. And if she was to accept this offer, okay, will you marry me? If she was to accept this offer, are they married? No. What would they be?
Engaged.
Engaged. And this is exactly how contracts work. Starts with an offer. And once you accept our offer, now we are in this legal arrangement that is leading up to a fulfillment. Okay? Acceptance means we're under contract. And so this engagement is the contract. What are they working towards? A purpose. We call that performance. Performance is what you are expected to do after you get under contract. Okay? The offer and the contract are the set of promises. And then you fulfill those promises, it's called performance. So a lot of things go up to getting to that performance. In this case, there's picking a venue, there's picking a caterer, there's picking a dress, there's rings, there's all these things. And it leads up to the wedding. In real estate, there's inspections, there's negotiations, there's transfer of title, there's transfer of money that leads to a transfer of ownership. Same concept though. Carter says, I'd like to look at an offer as a start to a conversation. Yeah, I mean, it is a starting point, and we're going to have to talk in great detail about offers, acceptance, counter offers. That's going to be a big part of basic contract law. On a side note, I want to point something out to you that you may or may not have realized. I want you to look at these two people right here. Okay, right there. See them? If you're ever on the internet and you've seen the meme with the guy looking at the lady in the red dress, that's them. Same people. They did a whole photo shoot, I'm assuming, for some advertisement. So there's actually a whole chain of events. One of my students found it. You want to hear the hilarious thing? There's a whole... I wish I could find it. I probably could. It would just take a while. But basically, there's like a whole storyline. You ready for this? This is so funny. The whole storyline is they're dating. He proposes. She accepts. They're engaged. Later, he's looking at that woman in the red dress. She's disgusted. And then she starts talking to the woman in the red dress. And then she dumps him and marries the woman. It's such a weird thing. There's a whole storyline with them. So she actually leaves him, and she ends up with a woman in the red dress. I don't know. Yeah. Like if you Google like woman in red dress, you could probably find it. But one of my students found it. It was hilarious. April says, "Can you repeat the four things an agency contract has to have?" Yes, under North Carolina license or commission rule, agency agreements, written agency agreements, have to have a definite termination date, the individual broker's license number, not the firm's, although there's a place to put it, but the license number of the individual broker is required. Signatures of all parties. Doing it again. Non-discrimination provision. There you go. Non-discrimination provision. The broker will act without regard to race, color, religion, sex, national origin, familial status, yada, yada, yada. It's called the non-discrimination provision.
Thank you.
Mm-hmm. You know, here we go. I just feel like you had to see it. So here's, like the starting point. You see how it's the exact same people? The red dress, and it's been like memed so many times, and that's a different cut of him, being distracted. I guess they just did like this whole photo shoot, and so there he is again. All right, and then now they're like, see, there you go. And then there's one of him by himself, just sad, muy triste, very sad, right? He's right there. So, yeah, I don't know. I'm sure it was for some type of marketing thing that they had to do all this, and then it just ended up online. But yeah, there you go. There's the full story. This is the one where he's not. So, Key says, so a contract can be oral or written. Sometimes contracts can be oral. Sometimes they have to be in writing. We're going to get into that. Some contracts are enforceable as oral agreements. Some contracts are only enforceable if they're in writing. It just depends. So, starts with an offer. After acceptance, we move on to performance. Right? Fulfilling whatever obligations we outline in the contract. It's called performance. And so in this case, marriage would be the performance in this engagement. For real estate, it would be the buyer and seller exchanging real property and money. For us, listing agreements, performance would be selling the house and getting paid a commission, right? So every agreement has its own set of performance, right? Whatever that may be, all right? So here's where we got to talk about different things that contracts can be, okay? And you've heard these words before because they came up in the agency contract section. Contracts could be express or implied. Express just means stated, okay? We have stated the terms. It could be orally or it could be in writing, but we have clearly identified the terms of the agreement. And so I told you when we talked about agency agreements, all agency agreements in North Carolina have to be express agreements. Even oral buyer agency agreements have to be stated. We have to talk about the terms within those buyer agency agreements. So implied means suggested by our actions, okay? And so North Carolina does not allow us to operate under implied agency agreements. But please don't get confused. There will still be discussion of implied contracts and implied agency agreements on your state licensing exam, because some states do recognize implied agreements. North Carolina doesn't. And so an implied contract, even outside of agency agreements, is one that is suggested by our actions. I want you to think about it, okay? Have you ever gone out to eat at a restaurant and you sit down at the restaurant and they bring you a menu, and then immediately after they bring you the menu, tell me if this is what happens. They say, good evening, sir and or madam, that is our menu. If you would, take a look at it and find what you desire to partake in this evening and inform us, and we will inform the kitchen. After informing the kitchen will take a reasonable period of time to prepare it, and we shall bring it out for your consumption, plus drinks if desired. Upon your completion of consumption, we will bring you a bill that we ask that you pay in a timely manner, plus gratuity. Do you have any questions, comments, concerns before I hand you this contract to sign? That never has happened to you in a restaurant, has it? You know why? It's because you are creating an implied contract. Listen, folks, if you take your tuchus into a Chili's, okay, and you order some margaritas and some fajitas, you know you're going to have to pay for them, right? I said fajitas. Don't get excited. I just put some weird emphasis on it, okay? Fajitas. Okay? And get it with a side of jalapenos. It's very, very formal. That's all right. So that would be an implied contract. Now, understand, some implied contracts are absolutely enforceable. If you don't believe me, try getting up and leaving that restaurant without paying. Oh, it's enforceable. They're going to follow you out. They're going to look at your license plate number. They're going to call the popo, and they're going to turn you over. So some implied agreements are absolutely enforceable. But we don't recognize agency agreements in North Carolina that are implied agreements. But implied contracts do very much exist, okay? It's our actions suggested that we understood what our obligations were. I was doing this, you were doing that, right? That's an implied agreement. Suggested by our actions. Express means we stated it, right? We clearly stated the terms. Please don't get confused. Express could be oral or written. Doesn't have to be one or the other, okay? Both written and oral statements would be express. The only thing that makes it express is we have talked about what you're getting, what I'm getting, what I'm doing, what you're doing, what the promises are. That's express.
And it's not accepted in North Carolina.
Well, implied agreements are accepted in North Carolina, but not for agency agreements.
Not for agency.
Yeah, agency agreements are not recognized in North Carolina. You're not entitled to compensation in North Carolina for real estate brokerage unless you have a written agency agreement.
Okay,
Yeah.
gotcha.
And written would, of course, make it by default express. But implied agreements, you know, between parties in any number of ways that they could happen could potentially be enforceable in a court of law in North Carolina, depending on what it is. Just for agency contracts, and that's where I told you. You got to think about contracts in general. Are there some contracts in general that would be enforceable in a court of law that were implied agreements? Yeah, of course. Right? The restaurant mentality. If you walk out, they can force you to pay. I mean, they can press charges, you know, on you and call the cops. So plenty of implied agreements are enforceable, but specifically agency contracts are not recognized unless they're express. So implied, suggested by our actions. Okay, doesn't have to be not stated. You know, I did this, you did that. Our actions suggested that we had this mutual understanding and agreement of willingness to act or cooperate and do X, Y, Z, PDQ, whatever it may be. Now, we got to talk about a very important and testable concept within this contract discussion, okay? I'm talking about different ways that contracts can exist, and we're talking about implied versus express, and then of course there's obvious understanding that express could be oral or in writing. And so what that means is there are some agreements that we come to that are just verbally spoken. They're still considered express, but they're just verbally spoken. Well, there is a piece of legislation, if you will, in North Carolina called the Statute of Frauds. And I want you to think about the name, the word, right? The Statute of Frauds. What is a fraud?
Someone who is misleading or doesn't do what's promised.
That's exactly right. Somebody who is misleading or doesn't do what is promised, okay? And so we have this Statute of Frauds, which is basically a doctrine that states there are some things that are so important and probably have a higher likelihood of people trying to commit fraud that we will not recognize oral agreements on these things. They're too important, okay? So North Carolina has the Statute of Frauds that says certain things have to be writing in order to be enforceable in a court of law. Okay, it's called the Statute of Frauds. But please understand a couple of things. Number one, I'm gonna come down here. This right here, agency contracts, is not part of the Statute of Frauds. Agency contracts do have to be in writing. I just told you that, but that's because of North Carolina License Law and Commission rule. It's not the Statute of Frauds that states that. So let's take that out of the mix. I like for you to know the actual information, why it is what it is. So let me give you some examples here, okay? One of the types of contracts named on the Statute of Frauds is contracts for the sale of real property. And so what that means is, if we had an oral agreement for you to sell me your house and me to buy it, and one of us did not fulfill our obligations, it can't go to court. Because the only contracts for the sale of real property that can go to court in North Carolina is those in writing, if it's for the sale of real property. That's what this whole thing says. If it's a type of contract named on this list, it is not enforceable in a court of law unless it's in writing. And the whole purpose of this is to minimize fraudulent court hearings over ownership to real property and things of that nature. But if it's not named on this list as required to be in writing, it is very much enforceable in a court of law, even if it's just an oral agreement. So let me give you the examples of what's on the Statute of Frauds, okay? Contracts for the sale of real property, leases on real estate exceeding 3 years, promissory notes, deeds of trust, restrictive covenants, and deeds themselves. All of these things have to be in writing to be able to go to court over them. Now, let me point out one of those specifics. I said leases in excess of how long? There you go. 3 years. So if Lisa and I came to an oral agreement, and Lisa is renting my property for a year, and we have a handshake on it. Lisa's going to pay me $1,200 a month to rent my property for the next year. We have a 1-year lease agreement, but it is oral only. So I want you to think about what I just told you. Lisa stops paying me on month 4. Can I take Lisa to court?
Yes?
No, you cannot.
No? Alright.
Of course I can. Folks, I said if it's on the Statute of Frauds as a required to be in writing, I can't take it to court unless it's in writing. The only leases that are required to be in writing is if it exceeds 3 years. Me and Lisa had a 1-year agreement. That is less than 3 years. Can I take Lisa to court over an oral agreement for this lease? Yes, of course I can. If it's not named on the Statute of Frauds, the courts will hear it. They will. Even if it's an oral agreement. Now, is it going to be easy for either one of us to win or prove what we got going on based on he said, she said? No. But will they hear it? Yes. So this is why nobody lets you operate off of a 1-year oral lease. It doesn't protect you very well, but could we still go to court over it? We could, because it wasn't required to be in writing to be enforceable in a court of law. So let me give you a different example. Claudia and I sign a 5-year lease, or we come to a 5-year agreement. And after 1 year, I kick Claudia out. And she wants to go to court. She calls up Judge Judy and she wants to go after me because we had a 5-year agreement and I just backed out on it, right? I just didn't do what I was supposed to do. And here's what's going to happen. She's going to go to court. And I'm going to say, well, what are you complaining about? What's the problem? And she's going to say, well, I had a 5-year lease with Seth at this commercial property and he kicked me out after 1 year and I want to go after him in court. And they say, great, show me a copy of your lease. She's going to say, well, it's an oral agreement. And they're going to say, sucks to suck, ma'am. Have a great day. Because they will not hear it because it was a lease exceeding 3 years, which required it to be in writing to be able to take it to court. You see the difference? Not everything has to be in writing to go to court, but if it is named on this list, it does. So, conversely, I told you deeds have to be in writing. Deeds show ownership of real property. So if I wanted to claim that I own Jonathan's house, and I went to court and I said, I own Jonathan's house, Jonathan Owens, he's in my house, I own it. They're going to say, show me the deed. I'm like, well, I ain't got one. I'm telling you I own it. They're going to say, go away, crackpot. But if I falsify a document that says I own Jonathan's property, they'll hear it out in court. Of course, it'll be found out eventually through an investigation that I falsified the documents and it has no legal standing whatsoever, but they would have to hear it because it was being writing at that point. And they couldn't prove that it was fake until they looked into it more. What you got, April?
So to kind of flip that scenario of the 5-year lease, so say you did your 5-year lease and then like you hit 6 years and now I want to kick you out. Like, how do you take that to court if the person won't leave? Or is that just where you get into, like, eviction? And
yeah, that's called a summary ejectment, which is a legal eviction proceeding. And so with commercial leases, when we're dealing with 5 years, these are typically with commercial leases when they're this long, not residential. And so we'll get into it. It's called an estate for years. And so these estate for years leases, ironically enough, it's not about the time frame. It's about how they end. They have a very hard end date. So if we say 5 years and you're still there after 5 years, I can evict you easy. Because, there's not a lot of protections for commercial leases. There's a lot of protections for residential leases. So I just have to go in front of a magistrate and do the summary ejectment proceeding to kick you out. Yeah. So the statute of frauds is, as I said, a doctrine. Now, every state has their own similar kind of thing, but, the North Carolina statute of frauds is what I want you to focus on for your test. Not everything has to be in writing in every state, but a lot of states have very similar laws and rules for things as important as real estate sales contracts, promissory notes, restrictive covenants, leases exceeding 3 years, and things of that nature. So we'll circle back around to the statute of frauds. We'll talk more about it. Plus, there's another rule or piece of legislation in North Carolina that deals with certain things needing to be recorded. And so we'll talk more about that down the road. And I told you, when I say recorded, I mean it's been put in the public record at the Register of Deeds. Okay, the Register of Deeds is the place that you go to record information that is open to the public. If you drove past a house, you're like, oh my God, that's a really cool house. I wonder who owns it. You can go to the public record, the Register of Deeds, and look up who is the legal owner of record. That's why it's called the public record. You can look it up. I can look it up. Anybody can look it up when you learn how to navigate it. So certain documents also need to be recorded to protect your interest. Statute of frauds only deals with in writing. There is a different piece of legislation. I'll go ahead and tell you it's called the Connor Act that deals with the recordation. Certain documents need to be recorded. And the lists are almost identical, believe it or not. But one deals with enforceability in a court of law. One deals with protecting your interest against third-party claims by recording it. Okay? So, when we talk about what contracts can and can't be... I'm sorry, April, what you got? Where's your hand just up? Yeah.
Well, I was just wondering, so where do, notaries come in? Like, if you don't go put something in with the courts, does having something notarized?
You can't record anything unless it's notarized.
Okay.
Yeah. So you have to have documents notarized to be able to legally record it. And so that's where it would come into play, because you have to have a witness who attests under, penalty of law that they saw that you were who you say you were, that the, parties both signed the documents, and then that way it can be legally recorded because it, was done in front of a notary. We're going to talk about deeds a lot towards the later sections, kind of backwards, but so we talked about contracts being express versus implied. There's a couple other things that contracts can be. So let's start with bilateral and unilateral, okay? And so I want you to think about this for a second. First and foremost, what does bi mean?
Two.
Two. What does uni mean?
Singular.
One. And here's where a lot of people make mistakes, okay? What do you think bilateral contract means?
Covering two clauses or points.
Promise between two. Both parties agree to the terms.
So you're all kind of touching on it. Bilateral versus unilateral is how many promises there are. Okay, promises. Because a contract always has to have at least two people. A lot of people get confused. They're like, oh, bilateral contract is with two people. Unilateral contract is one person. Folks, let me point out something to you. You can't have a one-person contract. That's a silly goose thing to say, okay? Because you know what that is? That's a Weight Watchers contract, slick, right? I swear I'm going to do it this time. I'm going to sign this and hold myself accountable. I am not going to eat those cookies, right? It's an accountability contract if it's just one person. And you know what happens? One night when you're hungry, that thing goes in the shredder. I didn't sign you can't prove it. Right? So it's not parties, it's promises. So bilateral contracts have two promises. Unilateral contracts have one promise. Still two parties, though. And so I want you to think about it. If I say a sales contract in general, you think that's a bilateral contract or unilateral contract?
Bilateral?
It's bilateral. Let me oversimplify the promises for you. I promise to give you my house. You promise to give me money. There's two promises. What about a listing agreement? You think that's bilateral or unilateral?
Bi.
Same thing. I promise to put forth my best efforts to help you sell your house, and you promise to pay me if I do. Buyer agency agreement, the same. Most contracts are bilateral. Promise for a promise. Okay? Most are bilateral. However, there are some contracts that are unilateral. And so let me give you an example in a very simplistic layman's application, and then I'll give you the more complex real estate application, okay? If my neighbor kid was outside one day and he was mowing his family's yard, and I look at him and I say, hey, if you mow my yard, I'll give you $50. He says, okay. Did that kid promise to mow my yard?
No, he just acknowledged the offer.
He just acknowledged the offer. Did I promise to pay him $50 if he did it?
Yes.
Yeah, so that's unilateral. If I come back to my house later in the afternoon and he's done it, I owe him $50 because I made that promise to him. If I come back later in the afternoon and he hasn't done it, I can't be mad. One promise is made, and the other person gets to decide if they're going to go through with it or not. Unilateral. So let me give you an example of this, okay? This is very testable. One of the most common unilateral contracts, the most testable unilateral contract that you need to know about is called an option to purchase contract, okay? An option to purchase contract. And so if I go to Mike and I say, Mike, I think I'd like to buy your house. I say, how about this, Mike? Would you be interested in selling me your house for $1 million? Does that sound doable to you, Mike? Would you sell me your house for $1 million?
Sure.
Sure. Okay. So Mike and I agree to some terms, right? $1 million is fair. And I said, but Mike, I'm not sure yet. I think I want to buy your house, and I think, $1 million sounds good. But how about this, Mike? I'll give you $3,000 if you give me 3 weeks to decide if I'm going to buy your house for $1 million or not. He says, that cool?
Sure.
Sure. So I'm giving him $3,000, and this is called an option period, okay? But we've already negotiated the terms. But I want you to think about this. Did I promise Mike that I'm going to buy his house for $1 million? No. I said, let me think about it, right? Give me 3 weeks to decide. But did Mike promise to sell to me for $1 million?
Yeah.
Yes. That is a unilateral contract. If I decide to buy, Mike has to sell. But there's that if, right? I have not promised. That's why it's unilateral. There's one promise. Mike promised to sell to me for $1 million if I decided to buy. Mike just sold on a piece of paper and held it up. That's why I always like to use these numbers, because then you're more likely to go along with me, right? Unless you got like a $2 million house, Mike, and then you might go to hell. But, I like to use big numbers because it makes these scenarios easy. Because I'd sell mine for $1 million too. You best believe it. So, does that make sense? That's a unilateral. But, we've already negotiated the terms. If I decide to buy, Mike has to sell. That makes it unilateral. There's one promise. However, if I exercise my option to purchase, in other words, I say, Mike, I'm buying. Now we're in a bilateral agreement. Because now I promised I'm buying and Mike has still promised to sell. When you exercise your option, you move into bilateral. There's now two promises. Yes, I'm buying. Yes, he's selling. Does that make sense? So we'll talk about unilateral a little more down the road when we get into some different contracts. But that's the most testable one, is this option to purchase is a unilateral. One promise only. Still two parties, but one promise. So bilateral agreements, two promises. Example would be John promises to pay Seth $400,000. Seth promises to transfer ownership of his land to John. Promise for a promise. Unilateral, I told you, is one promise. So I just gave you the example of the option to purchase. So here's that same example, popping back up. If you cut my grass, I'll pay you $50. One promise, right? Unilateral.
So could you say like a unilateral agreement is almost like a triggered agreement, like if this, then that?
Yeah, because there's always an if, right? If I decide to do this, then you have to do that. Always, yeah. So let me give you an example, and folks, don't answer too fast because people make silly mistakes on this, okay? If I give you an example, and I say, Carl owns a home in Mebane and has signed a purchase agreement promising to sell the home to buyer Cassie for $350,000. Cassie has promised to close on the home at that price no later than July 15th of 2022. Would this be a bilateral or a unilateral?
Bilateral.
Bilateral. Promise for a promise. I promise to give you money. I promise to close no later than this date, meaning take ownership and give you the money. There's two promises, okay? Two promises. And there's actually multiple promises, but basically what it's saying is, in a real estate sales contract, there's actually a group of promises from the buyer and a group of promises by the seller. Still a bilateral contract. Unilateral just means, it could still be a group of promises from one and then no promise from the other. So it's not always just one. Typically it's a group, right? Transfer title to you, keep the house clean, deliver it the same way that you purchased it, yada, yada, yada. Let me give you one more example here, Okay. Brenda has signed a purchase agreement as a buyer of a piece of vacant property in Orange County. Seller has agreed to sell the land to Brenda for $1,450,000 with a scheduled closing date of August 10th of 2022. Brenda has 30 days remaining in an option period that allows her to change her mind and terminate the agreement. Would this be a bilateral or a unilateral?
Unilateral.
Unilateral, because they have that option period. They have the right to walk away. They don't have to buy. They've not promised to buy. Let me think about it. And if I decide to buy, you have to sell, right? Unilateral. So with contracts, there's a lot of different pieces, a lot of moving parts. And as I told you in the definition of a contract, one of the big things that we're looking for is that word enforceable. Because if it's not enforceable, it's worthless. What you got, Jacob?
Would the open seller's agreement be a unilateral then? Because someone else can sell to anyone else, and you're not guaranteed the payment?
The thing about that one is I have promised to try to find you a buyer, and you have promised to pay me if I do. So I wouldn't necessarily group that in there because it's not so much, I guess it would depend on exactly how you articulated it, right? When you're doing it, if you bring me a buyer, then I'll pay you 3%. Sure, that's absolutely unilateral. But if I promise to put forth my best efforts to find one and you promise to pay me if I find one, that's still bilateral. But we're not going to try to trip you up on the test on whether or not that one's unilateral or not. But yeah, I mean, subjectively, you could look at it as either depending on the exact way that we articulated it, what the actual agreement states, right? So I told you the magic word for contracts is enforceable, okay? Otherwise, there's no point, right? 0 point. If it's not enforceable in a court of law, then you really should have just had a handshake, okay? Because that's about all that you could guarantee is whatever strength that a handshake has. So we want to make sure that it meets the criteria to be enforceable in a court of law, whatever that looks like for the given contract. The reason why I say the given contract, I told you, some agreements are enforceable just orally. Some agreements have to be in writing. Some agreements have to have certain things. And that's where this adds another level to what you need to know under basic contract law. So we want to do contracts in a way that allows them to be enforceable so we can feel warm and fuzzy inside that you are going to do what you said you're going to do, because if you don't, we can enforce it. Whatever that looks like. And there's a lot of different ways to enforce a contract, right? There's remedies if you don't do what you say you're going to do. Sometimes monetary. There's also what we call things like specific performance, where we try to force you to do what you said you're going to do. And we'll get into that some more in just a minute. But this enforceable word is very, very important because contracts hold no weight unless you're willing to go to court / can go to court. Because if you can't go to court and you won't go to court, contracts are worthless. What was the point?